Good morning. My name is Lori Craner, and I am co-chairing this workshop along with Norman Cate, who's over there. We are thrilled to see so many people here at our workshop on the future of privacy, notice, and choice. I want to start with just a few housekeeping items. So those of you who are looking for the restrooms, they are basically behind that wall out there. Let's see, there's Wi-Fi instructions in your folders. There are power outlets behind the monitors. The microphones in front of you, during the discussion time, which I hope everyone will engage in, those microphones are live. So all you have to do is talk into them. The green buttons that you see are the mute buttons. Right, so if you're like talking to your neighbor and you really want to make sure it doesn't get picked up on the microphone, press the green button. But in order to be picked up, you actually all you have to do is lean close to your microphone and talk. Let's see. In this room, we're actually not supposed to have food. We can have drinks, but not food. So eat your food quickly. But during lunch, if you just keep the food out there, then we won't get in trouble. All right, a few other things. I want to thank our sponsors. We have a number of wonderful sponsors. I especially want to thank Facebook and Maritza Johnson from Facebook, who basically nudged us to go ahead and do this workshop and then provided the funding necessary to make sure that it would happen. I'd also like to thank Scilab at Carnegie Mellon, which provided a lot of logistical support and website in order to make this happen. The Privacy Engineering Master's Program at Carnegie Mellon, and Tiffany Todd, who is out there at the registration desk, and many of you have emailed and talked to her, and she has done an enormous amount of work in order to make this happen. Also the PhD program in Computation, Organizations, and Society, and the Engineering and Public Policy Department at Carnegie Mellon, and then the Usable Privacy Project, which is an NSF-sponsored project here at CMU, and you'll be hearing more about that project later today. So thanks to everybody who was involved in actually making this happen. We're going to get started now with our morning keynote speaker, and I'm really delighted that we were able to get him. Fred Cate will be giving the opening remarks to hopefully provoke some thought and discussion for the day. For those of you who don't know Fred, he is a distinguished professor of law at the Indiana University Maurer School of Law and director of the Indiana University Center for Applied Cybersecurity Research and Center for Law, Ethics, and Applied Research in Health Informatics. He specializes in privacy, security, and other information law issues, and appears regularly before Congress, government agencies, and professional and industry groups on these matters. He is involved in many, many organizations, too many for me to read right now. I first met him probably about 10 years ago when we were both on an advisory board at Microsoft. So he has a lot of interesting things to say, and so rather than me talking, I will let him come up here and talk to us.
Thank you very much. I couldn't be more delighted to be here, and I appreciate the opportunity. I asked Lori on the scale between provocation and diplomacy, where would she like me to fall? And knowing me very well what she does, she suggested maybe someplace in between. It would be a little dangerous to go all the way on the provocation scale. But I will nevertheless, I suspect, especially here in the really home, I mean the international home of research on usability and improving the quality of privacy notices and consent opportunities, I may be speaking heresy, but I do that with a great admiration for the work here. And I should also, if I had slides, they would probably each at the bottom refer to research by Lori and her colleagues. So let me just acknowledge that debt to start with. I think this is an audience very well versed in privacy, so I'm going to take advantage of that to take some things as given, and if they're not, we can come back to them in discussion. But really, ever since Alan Weston wrote his groundbreaking study in 1967 on privacy and freedom, where he defined privacy as, and I'm quoting, the claim of individuals, groups, or institutions to determine for themselves when, how, and to what extent information about themselves is communicated to others. Ever since that definition, we have tended, in the United States, in Canada, and certainly in Europe, to treat privacy as being control of information. And the high standard, the gold standard of privacy protection was provide adequate, complete notice and get informed consent. These were the two requirements for privacy, and we see it reflected in almost all of our privacy instruments. Even those that don't in fact do that, they claim to do it. In other words, they say at the start, this is what they're trying to accomplish, even if they later take it away in the exception. So for example, the OECD guidelines talk explicitly about the fact that you need notice, choice, and purpose limitation so that the subsequent use of the data is limited by the notice you provide at the start, where appropriate with the knowledge or consent of the data subject and with the consent of the data subject are the bases for processing data under the OECD. Similarly, the Federal Trade Commission, some of you weren't even alive then, which is a slightly annoying subject, but back in the 1990s, reported to Congress that after its examination of fair information practice codes around the world, it found that common to all of these codes are 5 core principles. I think you know what those are. The 2 most important of which are notice and choice. In fact, according to the Commission, and again I quote, the most fundamental principle is notice, because without notice, a consumer cannot make an informed decision about whether and to what extent to disclose personal information. Obviously quoting Alan Weston without giving him credit. This is reflected even today, though. This is not a waning concept. So the Obama administration in 2012 released its Consumer Privacy Bill of Rights, and the first principle, and again I quote, is consumers have a right to exercise control over what personal data companies collect from them and how they use it. By the way, this is a good example of a document that doesn't subsequently provide that right, but it acknowledges rhetorically that that right should be the foundation of data protection. Now, in Europe, Europeans are fond of arguing that they don't use consent. And there's some basis for this argument, that they don't use it as much as we do in the United States and in Canada, but not much basis. And in fact, after recently being chastised at a talk at the OECD in March on this subject, I came back, the draft regulation pending now in the European Union uses the term consent more than 100 times. Consent is the first basis listed for the lawful processing of data. It's a condition for the processing of personal data concerning a child. It's a basis for processing sensitive data. It's an exception to the prohibition on exporting personal data, and it's an exception on the restriction of the reuse of personal health data. It would be hard to have consent anymore if you tried to edit in consent to that document than you currently have. Now, the focus on consent has been much, and I think legitimately, criticized. And I'm by far not at all the first person to do it. Professor Paul Schwartz wrote years ago that these laws and many others reflected the privacy as control paradigm, which he described, the conventional wisdom seeks to place the individual at the center of decision-making about personal information by conceiving of privacy as a right of control over data use. What we have seen more recently, however, is a growing expansion of this criticism into, and not merely from academics like Paul and me and others, but into government reports. So the Federal Trade Commission, the Article 29 Working Party. In fact, if you read the twin big data reports released by the White House last month, they included the memorable language that the framework of notice and consent is unworkable as a useful foundation for policy. Only in some fantasy world do users actually read those notices and understand their implications before clicking to indicate their consent. Close quote. Now, these objections tend to fall along a spectrum. On the one end is the practical objections. You know, notices are long, they're boring, they're tedious, nobody reads them. We could do better. We could make them shorter. We could layer them. We could use icons. We could do things to make notices work better. And the other end of the spectrum, and I don't think these are two distinct categories, I really think this is a spectrum, are what I would call more foundational objections. That notice is simply an inappropriate basis, and that consent is an inappropriate basis for data processing. And that especially as the volume of data and the ubiquity with which data are being collected grows, these are simply unworkable. That it's not a question of could we make them better, can we dust them off, can we polish them up, all of which is true. We could do a lot to make them better. And again, much of that work has been done here. But rather that, particularly as more data are collected from sensors over which we have no control at all, and as more data is collected or inferred or created whole cloth by third parties with whom we have no relationship at all, the notion that notice and consent should be the basis for privacy is simply not merely unworkable, but undesirable. So let me just spend a quick minute outlining what I see as kind of this spectrum, and then inviting your responses. And I'll try to say something positive at the end, just to leave us on a happier note. So the complaints about the operationalization of privacy notices are, I think, well known. And I always like this language from Kent Walker, now General Counsel of Google, but he wrote this 13 years ago. You know, he described in an article in the Harvard Journal of Law and Public Policy, and he used these terms to describe notices, you know, overkill, masses of unintelligible small print that nobody bothers to read or could read, irrelevance, describing activities of so little concern to consumers that it's like leading a satiated horse to unappealing water, opacity, reflecting the bedrock truth that it's difficult to track, let alone describe all of the information exchanged in a typical transaction. Non-comparability or inflexibility. And inflexibility in many ways is one of those objections which transits the entire spectrum of objections. In other words, if you can't offer the service without the notice anyway, what good is the notice and the illusory choice? At the time, the then chairman of the FTC, Timothy Muras, put it somewhat more colorfully, and many of you will remember this, those of you who were alive then, when he described the Gramm-Leach-Bliley financial privacy notices in this way: the recent experience with GLB privacy notices should give everyone pause about whether we know enough to implement effectively broad-based legislation based on notices. Acres of trees died to produce a blizzard of barely comprehensible privacy notices. Indeed, this is a statute that only lawyers could love until they found out that it applied to them. And you may recall that the American Bar Association successfully sued the FTC to move lawyers out from under GLB. Now, not a lot has changed. In other words, despite enormous efforts to improve regulatory efforts, scholarly efforts, and so forth, we still see incredibly burdensome, opaque, irrelevant notices. I was struck by an article, the UK consumer watchdog group, which in March 2012 published a comparison of privacy and other user term notices from online sources, and for example found that PayPal's privacy, PayPal's here, I'm very sorry, that PayPal's privacy notice totals 36,275 words, which makes it longer than Shakespeare's longest play of Hamlet. iTunes is 19,972 words, which makes it longer than Macbeth. You might remember the 2008 study co-authored by Lori here, that just calculating that to read the policies of the most popular websites would take an individual 244 hours or more than 30 full working days each year. It's not really a big surprise that notices haven't succeeded. I don't know why anyone would be amazed when we look at what notices look like. But it is important to remember that there are reasons for the length and complexity of notices, and not only because of the complexity of the legal requirements and the business practices that they describe, but also because regulators have chosen to enforce them like contracts. And there was a clear signal sent when the FTC brought its really first case in this area against Eli Lilly and Company for security violation. And they pegged that security violation, which was a one-stroke coding error in an email, And they pegged it on the basis that Lilly had a privacy policy that said, we will provide adequate security. And they said, well, that's not adequate. So now I can guarantee you that privacy policy does not say simple things like, we will provide adequate security. I would guess you probably have 4 paragraphs of description of the effort. It will look like an FDA notice now. Because once you know these are going to be the basis for lawsuits, you're going to be more careful when you draft them, and you're going to have lawyers draft them, not humans. My apologies to lawyers as well. By the end, I will have offended everybody, and Laurie will be wondering where the diplomatic part was. But really, if we're to be honest with each other here, even when notices are reduced to cigarette pack-like warnings, this product can kill you, people just ignore them. And again, there's a lot of research from Carnegie Mellon to that effect. I was reminded of this yesterday. I was sitting in a security meeting with a bunch of security people in Washington using a guest internet wireless connection, which every time my Explorer connected to it, I got a pop-up message saying that the security certificate was out of date. We recommend you do not go here. The first big box is do not go here. And then you have to really look to find that, okay, I'm an idiot, I really want to go here. And I and every other security person in the room was clicking through those notices just as fast as possible. Right? It just doesn't matter. I mean, we have extensive research on this. FTC Chairman John Leibowitz, former FTC Chairman now, noted at the first of the Commission's 3 2009-2010 roundtables on exploring privacy that if there is one thing on which we can all agree, it's that consumers don't read privacy policies. Okay? Which is a pretty remarkable acknowledgement from the federal agency that's probably done the most in the world to promote their use. So I think that critique is pretty clear, whether or not you agree with it, and there might be a lot to take issue with or a lot to say we could do better with. But I want to move on to what I think of as these kind of more fundamental objections. And I'm going to run through these quickly because, again, they're going to be very familiar. And but let me just take a moment to illuminate. So one is the absence of choice. Notices that the purport to give choice but actually don't. Graham-Leach-Bliley is a perfect example. Congress requires that annually you get a notice that tells you you have absolutely no choice whatsoever other than about the disclosure of financial information to unrelated third parties for the marketing of non-financial services and products. Right. So by the time you've read the 6 sides of the privacy notice, you discover it was telling you little. A second objection is where there's merely the illusion of choice. This is one of my favorites. iTunes is the perfect example. Right? iTunes wants to update every single day, sometimes 3 and 4 times a day. You get the update, and then it says, do you agree to the new terms? Right? Well, you have 2 choices now. You can say, no, turn my device into a brick, or yes, I agree. It looks like choice. We can say, you made a choice. That's great. Good for you. But you had no real choice there. None whatsoever. And yet, making that choice shifts the liability for what happens from there on, from them to you. A point I'll come back to. We've seen a lot of attention to this illusion of choice issue, both from Europe and the United States, with the Article 29 Working Party issuing a series of opinions noting that consent is simply an inappropriate grounds for processing where there is not the ability to make a real choice. If you can't say no, then saying yes means nothing. And this would be the case, according to the Article 29 Working Party, for example, in employment settings, where you really just don't have much choice if you want to work at that employer, but to agree to their basic terms. A third problem around privacy notices that is more fundamental is that notice and choice are simply a poor basis, an inadequate basis for privacy. The Institutes of Medicine's Committee on Health Research and Privacy of Health Information wrote in 2009 that consent itself cannot achieve the separate aim of privacy protection. And I think that's a really important line. I take it very seriously, in part because Mark Rotenberg, head of EPIC, was on that committee and signed off on that language, and in part because it makes the point that privacy is different than consent. You can have great privacy without consent, and you can have lousy privacy with consent. And therefore, we run the risk, by focusing so much on notice and choice, of distracting our attention away from where it should be in a data protection context, and that is on protecting the privacy of the individuals involved. I think we see a good example of this, and I'm sorry, I know this is going to provoke Joan, if nobody else, with the breach notification laws following information security breaches. Now we see these throughout the United States. California led the way in this, as it has in almost all privacy protections. But as a result, we now see this saturation of notices, often when there's no risk and nothing the individual can do, even to the extent that the federal government, when it released its HITECH Act final rules, which include breach notification, noted that it is vital to, and again I quote, ensure that consumers are not flooded with breach notifications for inconsequential events which could cause unnecessary anxiety and eventual apathy. I don't think it needs to be put in the future tense. We already know what the take-up rate on things like credit monitoring and so forth. The apathy is overwhelming in this area. And in fact, recently a group of Dutch scholars, and I would direct you to their work, published a paper arguing that under the draft EU regulation, the requirements for expanded explicit consent will only have the effect of making consent even weaker, because it will just mean people pay even less attention to it the more times they're asked to make these meaningless choices. It is actually closely related to another issue, and that is the individual burden, the burden on you and me of all of these notices and consent opportunities. And that burden takes a lot of forms. As a legal matter, it takes the effect already, as I've mentioned, of shifting the responsibility. Right? I'm now liable for what Apple does with my data, because I accepted that liability. I agreed. You can't do that anywhere else in the world. You can't do that in any other form of consumer protection. Go to Best Buy, try to buy a TV and say you'll accept responsibility if it's a defective or fraudulent transaction. Federal law will not let you do that. But for privacy, we're happy to do that. We'll just shift it right to the user and let the user bear the notices. Moreover, we're stuck with the consequences even if we don't read the notice. Right? What we know with certainty across the board, with a single exception of telemarketing, is that whatever the default is going to control. 4 people, 5 people, that would be a huge response who would change the default. And so notices have a way of effectively letting the data user, in many cases the company, say, this is what we're going to do, and we know you're not going to look at it anyway, so congratulations. Now we've just made you liable for it. The consequences can be incredibly significant, and yet notices are they're like a shoehorn. They're a way of shifting that liability, of moving it, of smoothing it along. There also are, of course, other types of burdens on individuals, and one thing that struck me is I've done a fair amount of research funded by the NIH on HIPAA and its impact on individuals. And as part of that, we do focus groups. I don't do them because I would be hopelessly biased, but the National Health Council does them for us with patients and about HIPAA, their encounters with HIPAA, their expectations, and so forth. So there are 2 predominant responses, overwhelmingly predominant. They show up in 80% of the focus groups. One is, I thought you were already using the data for other beneficial purposes. Why would you bother asking my permission to do something so damn obvious? And the second is, the single greatest concern after discrimination, which is completely understandable, we now have at least federal law that addresses, about the use of data, health data, is I don't want to be contacted. Just don't contact me about it. I've had my interaction with the healthcare system. I'm not interested in another chat. Use my data, that's great, but please do not contact me, which is why we, of course, have federal and state laws that require us to contact the person again and again and again to use their data. But choice not only can have the effect of shifting this burden or of imposing this burden, it can also be a much broader disservice. Disservice to the individual, disservice to society. And there are many examples of this. Security would be a good one. When I board an airplane, I really hope that my pilot has had no choice about the supervision placed on his alcohol consumption or his suicidal tendencies. There are lots of places. Financial services is a perfect example. We take away all choice. We say we have it, but then we take it away in the next sentence of the law. Again, former FTC Chairman Tim Muris commented about this in context of credit reporting. He said, look, credit reporting works because without anybody's consent, very sensitive information about a person's credit history is given to credit reporting agencies. if consent were required, he continues, and consumers could decide on a creditor-by-creditor basis what they wanted, whether they wanted their information reported, the system would collapse. Because, of course, it would no longer be reliable. People would be selectively choosing their information. This is, of course, incredibly true in health information. It's another area where we've seen even as low as, say, a 3% opt-out for using data for research skews the data set so that its value for many types of research is eliminated. So that the choice about whether you can use my largely de-identified data in a subsequent research project has consequences not just for the individual making the choice, or in some cases not making the choice, but just the default carrying through, but has significant consequences for other people in the society. I was surprised, and I maybe should not have been. This will just tell you my own inadequacies. When doing the NIH work, I was always nervous about what ethicists were going to say. Here we are talking about in research context, you take away individual choice from the research subject. And the striking thing as I presented to a group of bioethicists after a group of bioethicists was how rich the literature is in pointing out how unethical it is to impose choice obligations on individuals when any of the prior conditions I've just described are true. When it's not a real choice, when they don't have the information to make the choice, when it imposes high costs on others. So we are operating in an area which is maybe legally correct, but theoretically, ethically principled, from a principled basis, weak. So let me just suggest 4 possible steps forward so that I say something more optimistic than just, I don't really like notice and choice. So one is, I think transparency really matters, and I think we have too often tried to make notice and choice carry the burden for transparency. They're not effective for that. Since nobody reads the notice, they don't really help with transparency a great deal at all. And the argument, well, privacy advocates will read them or attorneys general will read them, and that's the way we'll get transparency. Again, I defy you to read a privacy notice and find transparency in it. So if what we are interested in doing, and we should be interested in doing it, is finding ways for individuals to be meaningfully aware of and involved in the data processing system, this is not how to do it. There are a lot of better ways, again, many of which have been the subject of research here. But the reflexive resort to notice and choice, I think, has more to do with the fact that it's cheap, that it imposes an answer when regulators don't know what else to do, and that industry loves it because it lets them get away with effectively whatever they want. So it's a kind of perfect storm that notice and choice is always what we default to when we can't think of a more effective solution. By the way, it's not just limited to privacy. That's true absolutely everywhere. Second, I think we should use choice where it's appropriate. In other words, where there's a real choice to be made, where there's a choice with consequences to the individual, where there's a choice that the individual is competent to make, that's exactly where we should be using choice. Do you want me to contact you? That's a choice I can answer. I know. Do I want to hear from, can I share your information with a partner to contact you? I can make that choice as well. Telling me who you use to do your back office software processing and do I agree that they can do it in India is not a meaningful choice, right? I can't, if I say no, I'm out of your system. So we should be using choice where it makes a difference and where there are opportunities. Again, I think we've seen on mobile apps a significant advance in this area. This app wants to use your location information. May it. I can make that choice. I'm competent to make it. It's just in time, and it's exactly the right type of choice to be asking me. Similarly, and third, we should be using notices where appropriate. In other words, telling me about things that there's nothing I can do about it, that I have no choice, and especially where it's a place where the choice is already made for me. So I've always found that I'm just going to spend just really 35 seconds on this. When the Department of Homeland Security did its work on allowing border officials to seize laptops and mobile devices, the Secretary of Homeland Security, Secretary Napolitano at the time, spoke to the data protection commissioners in Spain and made the outrageous statement that in The United States privacy was protected because we gave a notice to people whose laptops and devices we seized. I mean, it's nonsensical. It's not an appropriate use of notice. If you have taken my laptop, giving me a notice saying you've taken my laptop seems a little weak. Interesting, it doesn't tell you anything useful, like the badge number of the agent who's taken your laptop. That would be useful. That TSA does not release that information, and neither does Border Patrol. Right? Telling me where it's going to be stored, that would be useful, but we don't tell you that either. Right? So I was sitting in Washington National Airport last night waiting for my flight to Pittsburgh, which, by the way, you can hold your breath during the flight and get here. It's such a short flight. I could have walked here. And I noticed there was never a moment at which the airport was not making a meaningless announcement. Right? The TSA has determined that you cannot take liquids. The TSA has determined that you must put your liquids in a bag. The TSA has determined it's orange. I don't know what's orange, but something at the TSA is orange. These are not helpful notices. You know, your car is about to be towed, move it. That's a useful notice. And that's what we should be thinking about. Now, let me just say, all of the issues we've talked about, I think, become more acute as we see the data environment changing today. So as we see not just a lot of data being disclosed by people and collected in transactions, but increasingly being captured by sensors and devices which we have no awareness of. You know, who knows how many, I see a camera, you all have cameras. You could flood me with notices right now and I would still have no privacy. Where more and more information is handled by third parties. Axiom, according to the New York Times, engaged in 50 trillion data transactions in 2012. If you send a notice and ask for consent for every one, I'm just suspecting you're going to burden the public. If you don't, if you ask for blanket consent, I suspect it's meaningless. And similarly, where we think about sensors that are no longer going to be necessarily concerned about an individual, like I'm recording your location with my cell phone, but sensors that are more concerned with industry. Weight and balance sensors in airplanes and so forth. These all collect personal data. It's easy to combine what seat is occupied with what person occupied that seat, and then you know my weight. I'm not sure giving me a notice on the back of the airplane seat saying, now you know my weight, is going to be very helpful there. So I think these challenges are only going to get increasingly significant, and nowhere more so as we see more and more data being created, being generated, being interpreted. You could give me notices all day long as I shopped in Target, but you never once would have told me that you were going to predict whether I was pregnant or not, right? For the record, I'm not. But you can, in other words, it's distracting, but it's also deceptive. It is, you can give notice about the wrong thing and say, like the magician, look at what's going on here, when what I really want to know is what are you doing with the data? So let me stop there. If this were, Congress or an industry group, I would say something exciting about the future and how we're going to walk into it together and make things much better. But I think these are actually incredibly hard issues. And I think until we get them right, until we start taking privacy more seriously, and until we do, and this is my last recommendation, which for me has been a huge sea change, and it's been a lot of work getting to it, and people like Joan and Joel will probably feel the need to lie down after they hear it. Increasingly, I think we need substantive legislation. We simply can't leave these critical issues up to the individual to say, if I can talk you into saying yes, I can do effectively whatever I want. Thank you very much.
So we have time for a few questions before the break.
If someone would revive Joel with smelling salts there, that would be helpful.
What would that legislation say?
Well, that's a really good question. I have a whole other talk on that. I think there are some things we know. In other words, I think one thing I would like to see, let me not speak for anybody else, is legislation that particularly focus on greatest impacts on individuals. So rather than thinking about data, like can we nail down data, like trying to nail down air, I would think about impacts on individuals. So we'd say, look, there's some things we just don't tolerate. Discrimination is one, and maybe we need a new definition of discrimination. And so I don't care how you get the data, and I don't care what consent you have, but if you're going to discriminate in an unlawful manner, that should be against the law. Similarly, I think we care a lot about data being used in ways that causes tangible harm to individuals. And for most individuals, that would be financial, but it certainly could be physical. And one of the things we have today, I mean, there have been 180 or more class action lawsuits brought that have been dismissed on the basis, effectively, of absence of evidence of harm. And we could really use some work, and I and others are doing that work, but it's going to take a lot more than us, to try to say, let's categorize those harms, and let's say this is a harm, and we're going to allow recovery for this harm. Not because I'm interested in seeing lots of money move, and by the way, I certainly don't want to see the plaintiff's lawyers getting lots of money, but because companies will then internalize the cost if they're going to have to bear it, and so might government agencies. And I think a lot of people have commented about this after the year-long Snowden disclosures, that if the NSA had known the cost to the economy and to industry and to others of its activities, it might have thought differently about them. But of course, it didn't even have a process for anyone warning it about the cost. And so part of what we have to do is internalize this in decision-making processes. Sometimes this is called moving to a more risk management approach. But that, of course, requires being clear about what the risks are. And right now, I mean, not even in Europe, where they would like to say they're light years ahead of us on this, they don't have the faintest idea what the risks are they're worried about. They know a lot about compliance, but not very much about why. Yes, please.
So you were mentioning the no choice. Like, for example, when you're getting an update from iTunes and it says, do you agree? And there's no other way to go forward except to agree. What is the alternative? I mean, one might be just to say, we're going to upgrade iTunes. And that's just the way it is, and you have no choice. What might be something else that would be meaningful in terms of that?
So I think there are a range of choices here, and largely these are public policy matters. And if we had a functional Congress, I would say they were legislative matters, but since we don't, they'll probably be decided by the California legislature instead. So one is that when you make an investment in a technology, should there be some period of time in which you have a right, protected by law, to use that technology without having your privacy rights diminished. So they can update it, they can make it more secure, they can add features, they can do all sorts of things, but what they cannot do is say, we used to say we don't share your information, now we're sharing your information. That you should, maybe there's a cooling off period. You get a year, you get 2 years, maybe it would depend on the amount of the investment. So, with a $400 phone, maybe it's a year. With a $4,000 laptop, maybe it's 2 years. That would be one way to think about it. Another way would be to be clearer about the process for doing retroactive changes. So, all this data we've been collecting about you, now we're going to use it in a different way. So, depending again upon the type of data, and I would be very risk-oriented about this. Maybe we want to really, if you will, raise the cost of making those changes, so that we make the company say, we really think it's worthwhile, we're willing to bear that cost, as opposed to, it doesn't cost us anything, so we're just going to do it without really thinking it through. Another way, of course, would be to prohibit changes to retroactive changes to data that's been collected in a commercial setting. There are all sorts of really more creative ways. I mean, for example, in Canada and Ontario, for example, we've seen some really bold initiatives around a lot of data protection issues, but one in particular around the use of data, health-related data for research, where effectively I'm going to misstate this and then others can correct me, but we have identified data custodians who comply with certain obligations. There's a data protection commissioner who sets those obligations. They're subject to audit, they're subject to oversight, and then they help provide the data to others or for their own use, but subject to those rules. And again, you notice I use the word data protection commissioner. Maybe that would be a helpful thing as well, is to have somebody, maybe it's an expanded role for the FTC, or maybe it's a state role, or maybe it's combined, so that you could actually go talk about these issues with someone without immediately drawing a target on your face for an investigation. I don't think these are easy issues, but I think we have spent almost no time trying to address them. We've spent a lot of time on making notices prettier and layered. And I mean, if you think about time, industry in particular, forget academia, that industry and the government have spent trying to work out the terms of layered notices. Given that nobody reads them to start with, I mean, really, was that worth that investment? We could have just given $1,000 to each one of the 2% of Americans who have read a privacy notice the whole way through and have saved the trouble. Yes?
I'm curious, in your talk you mentioned that there are some things where users can make choice. Others where it's not meaningful, like a choice of back office provider. But then you also want to provide transparency. And some of these updated privacy notices are exactly that, is providing transparency to who the back office provider might have changed to. Sometimes there's a new feature that if you use that new feature, it might require you to grant some additional consent. But if you make the practice of changing your privacy policy harder, don't you incentivize companies to upfront just request more and more permission, if you will, such that they don't have to face the burden of changing later on?
You're absolutely right. Let me say, by the way, that is the state of the law today. In other words, privacy notices today, if you go to a lawyer and get a privacy notice drafted today, you're going to seek everything. You know, for all other future uses on this planet or in the universe in any language now known or in the future discovered. And there's not going to be a whole lot of limit to that. So one thought about having some substantive legislation in the background is it might set some limits. You know, we might not count a privacy notice as a notice that says you have no privacy. We might actually seek. The second thing is I think transparency is poorly accomplished through most privacy notices. So I think there are a lot of ways to do transparency. I frankly would have done the same thing with most breach notices. I would have them filed with a central repository. I'd make the state AG the recipient of those. And so if you want to know the detailed transparency information about your credit card processor, you know, they can put it on their website, but it also ought to be available in some, you know, centrally available place. And that presumably could be changed under different terms than a notice on which an action is based. So when it says, we want to use your location data and we will only use it for these reasons, I'm pretty comfortable with saying, and that will be the limit on the future use as well. If you make that promise should stick. What I'm trying to get out of is the basis of making a bunch of gratuitous promises, or non-promises as they might be, or qualified promises, because we feel the need to do that, you know, to touch every, you know, we have this principle checked, we have this principle checked. It's not, the longer you make it, people aren't going to read it. The more you put in there, the less informative it's actually going to be to most people. And it includes a lot of irrelevant information. Even the Federal Trade Commission has suggested now that for certain activities that might be considered routine or expected, like how you process payments, you don't include it in your privacy notice anymore. You make it available somewhere, you don't hide it, but we don't try to force it onto the consumer every time that the consumer engages in a transaction.